well, we'll see what happened. Let's go.
To avoid a collision as permitted by an official traffic device. Okay.
Yes, Your Honor. So in terms of their arguments about the driving on the shoulder under Lothrop, their case that they're citing, the case itself says, and I quote, merely driving on an improved shoulder is not prima facie evidence of an offense. That's their case. It says the exact, that doesn't benefit them at all. In terms of Hardin, their own case, based on our review of the record and precedent, we conclude that the detaining officer did not have reasonable suspicion to stop Applee for violating Transportation Code Section 545.060. Again, that's their case. And in that one, that's where the vehicle's tires crossed over the fog line, just as in our case, into the shoulder. And in their own case, it says that was not reasonable suspicion.
Welcome to what had happened was.
When we take a peek into actual court cases and give you commentary based on our unique perspective and experiences, and also give you informational tips and tricks to help you avoid a what had happened situation.
Before we get started, give us a thumbs up, a tasteful comment. Subscribe to the channel to be notified of every video as they come out. All defendants are considered innocent until proven guilty in a court of law.
Sir, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 28, 2024, the officer came to a stop behind the defendant's vehicle, and the light turned green, and the defendant's motor vehicle proceeded, and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle.
So this case takes place in Texas in Judge Fleischer's court.
Yes, it does.
And the reason why they're so serious on this is they have the highest at this recording. They have the highest DUI in like the country.
Right, incidents, yeah.
Incidents, accidents, deaths, everything.
Right.
Statistically, they're number one. So they have to take all of these seriously. So anything that's out of place, they're gonna stop them for immediately.
Right, makes sense.
So when he jerked over to the shoulder, and then even though he corrected, they're still like, let's find out, make sure everything's okay.
Right. Judge Fleischer also makes an effort to always mention that they're number one.
And that's not a good number one.
It's not.
You don't want to be champions and you don't want to win the DUI championship.
That's the
There's
one
no trophy.
That's the one trophy you don't want.
There's no trophy.
No.
And I think the prizes are really bad.
Very.
The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming one alcoholic beverage, and standard sobriety tests were administered. HGN 6 out of 6. The walk and turn on one leg stand.
Who's going to admit to more than one drink? No one's going to admit to having.
We haven't seen a case yet where the person said, "Yeah, I was drunk." No. Or
You know,
I had 5 drinks. Or nothing. They only say one drink.
You know, I got sloshed.
No, they're never
They're
going to say.
never going to say that. No.
They're only going to say, I only had one drink. We've done several cases, and they always, I haven't seen one yet. There might be one, but I haven't seen one yet.
No. As a matter of fact, I'm putting on another case. One guy he said that he got drunk off of one beer.
Yes.
Look for that video. Judge Bryant.
It could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Wow.
Woo.
0.192. Wow.
So that means out of 100%
Yes.
of the blood of your body,
Yes.
19% of it.
Yes, 19.2% of it.
19.2 of it.
You want to get into that number so that you don't have to ask for that 2 minutes.
19.2% of it
Yes.
is alcohol.
Alcohol. Which means people who be blowing 0.3 and 0.4. I mean,
that means 30%
and 40%.
40%.
I mean, wow. I mean, it's almost half your whole blood.
So then
Wow.
You want to have more zeros
Yes.
than anything.
You want 0.000, or if anything, 0.00.
And they'll tell you, and they do a measurement because they have classes that they do a measurement to see, to make sure they're doing the right calibrations to see how long it takes for somebody. And they do these studies. Now, some people, they invite them to, and they have like a little party, and they do allow them to drink alcohol, and they provide
county-sponsored Ubers.
County-sponsored Ubers, legitimate ones that they drive you home or whatever, and they make sure, and they will tell you, and everybody's assigned a particular type of liquor,
right?
To know, okay, so somebody drinking this, it will take them this amount to blow this amount, and they do like a focus group, so they do different people of different heights and different weights and things like that,
men and women.
And they do men and
see
women.
the effects of the and they make sure the same liquor on a man and the same liquor on a woman.
It's all about it's all about your weight, your muscle, and your body mass index.
And they also go by tolerance. They ask some people,
and some people have a higher tolerance
who are not drinkers, and some people who are drinkers, to see the difference, and also how they.
And they even, if I'm not mistaken, they even give them food. So it's just to see how.
Yes, because food is a factor.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
It's possible, Your Honor.
All right. How many prior DWIs does he have?
It's one prior, Your Honor.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart, and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel, and he'll tell you when you have to come back. You understand?
So I need to wait for him now?
We're going to have you wait for him now, but after today, I'm going to waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence to work the case up.
Wait for him.
Right. I'm going to have you sign a reset. I'll have you meet with Felicia for bond conditions, and we'll just have you waiting back for Mr. Stewart to show. Okay? Please.
Right this way.
That was nice. He doesn't have to continue to appear while this case is being
That's
done.
very accommodating.
The lawyer can just come in.
Yep.
Well, maybe you know what? Maybe he don't want to take no chances on him having another drink.
Right, or making a mistake and not getting there on time.
Yes.
This way, your lawyer knows he got to because he's going to get paid for it.
Right.
He has an extra incentive for being there because,
Plus, sometimes they have other cases or whatever, so they
Right.
kind of schedule them all the same day, and they just do everything.
So see, again, this is the benefits of having a lawyer.
Mm-hmm.
Sometimes they'll waive your appearance. Not all the time,
But sometimes.
but sometimes.
Yes.
Come on up.
Good morning.
Hey, how are you? Mr. Stewart, what's new?
Sir, how was your New Year?
Great. We did PC on your case.
Okay.
We just did stand-up. What's your guy's name again?
My last name is Allen, Your Honor. I would like to make an argument on PC. I don't know whether.
Absolutely. I'm always ready to hear it. So refresh my memory. What happened?
So in Allen's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The defendant,
But he had expired registration, right?
No, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there were other vehicles around the vehicle before the driver jerked back in the lane. So he went into the shoulder and there were other vehicles.
Go ahead.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here, elucidated, is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of the safety of anybody else out there on the roadway. The shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to then stop him. This is insufficient information, and I would argue that there's not valid probable cause here.
So he said there's 9 reasons in the state of Texas as to why he could have legally went and pulled over to the shoulder, and that there's not enough reason, probable cause, him drifting into the shoulder by the police officer's admission is not enough for them to have pulled him over to initiate the stop to ascertain that he was under the influence. So let's see how this is going. This is getting.
But once again, I'm saying they have such a high incident of DUIs.
Yes.
That he said, the lawyer said, well, there's 9 reasons why he could have pulled over to the shoulder of the road.
Well,
yes.
Yeah. See,
okay. But let's add in one more.
Right.
He's under the influence. He's not sure where he's going.
Right.
That's a reason too.
That's a reason too.
So while there's 9 reasons why you could, there's another one why you might have.
Well, let's see how this is getting very interesting. I see where the lawyers come from. He's saying that wasn't justification to pull him over in the first place just because he drifted. Because he was stopped at a light lawfully, and the light changed, and he legally went through the light. There's no other things going on. There was no violation of equipment violation, the problem with the paperwork, nothing. Just the fact that I pulled out, I was stopped legally at a light in the lane. Yeah. And the car.
The lawyer said that wasn't enough.
Because it could have been he might have had his hand off the steering wheel at that time, and the wheel might have whatever. Let's see how this is going to turn out.
But once again, I'm going to say it again. They have a high incident of DUIs.
I understand.
And when they stopped him, he did blow.
Yes, but now he's saying there was no reason to stop him.
Okay.
Let's see how this goes.
All right, let's see.
Let's see how this works out.
On this case,
I think he has a valid point where, perhaps he's, well, I mean, I don't want to speculate. And you're saying, well, maybe he did it because of this, but I don't want to speculate, right? Because were there other cars? I don't know. Was it dangerous? I don't know. I mean,
of course, Judge, but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason for a stop.
Right, but you got to articulate facts as well, right? So, according to the statute.
Right, and I understand because we've had this issue before where it's failure to maintain a single lane, but we're unsure if there's other vehicles. That I can appreciate and understand. But in this case, the officer did specify that there were other vehicles in the vicinity. And under Texas law, that is sufficient for a stop.
I disagree. I think that when we...
So the defense attorney, he just raised a very good argument. He said, because you heard the prosecutor, he said there were cars in the vicinity. He's like, I disagree. Because I'm thinking about, I'm waiting to see, I don't know. I jumped the gun, but I'm waiting to see what his argument's going to be. It's got to be brought up because he made a statement that I caught that. He said there was cars in the vicinity. That's a very vague statement.
It could have been a parking lot across the street.
Exactly.
It could have been a car dealership. It could be one of those places like some cities have that, it's like I call it like a motor mile.
Right.
It's like one dealership is on one side of the street and another dealership is on another side of the street.
Yes.
You keep going.
It's just cars for miles.
Cars and cars. They're not going anywhere.
No, but they're in the vicinity.
They're all together.
But let's add one thing that he also left out. Remember, he got pulled over for DUI, and that usually mostly happens at night. It doesn't happen in the daytime. Very few people run around, all messed up like that. There are some,
unless they go to really
not day parties. But there's mostly these stops happen. DWI stops for the predominantly majority of stops at night.
Most of the time, yeah. Unless you go into like an awesome day party. Shout out to you if you only go to day parties. Put a 3 in the comment if you only go to day parties now because you can't be bothered being out at night with alcohol and people. You have people that's all they do now is go to day parties.
Yes, I don't even go to day parties because I just can't be bothered.
Yeah, well, I don't go anywhere. But I'm just saying, you got people that go to day parties now. It's a big thing. You know, like Gen X is big on day parties.
Yes.
Which is funny because that's when we were little. We went to day parties.
Right. It was mostly in
but
school.
they lasted to the next day because our parents were boomers and they was having a great time.
Right.
So you'd be asleep on the couch somewhere or next to a speaker.
And still wake, it was still going on like, wow, what's going on? And they had clubs like that too.
So maybe that's why we don't like to go out anymore.
Yes, probably so.
Look at the statute for trying to maintain a single lane. The second half of the statute is that it endangered somebody, and there's no indication here that there was any danger.
Was it 545.460? Isn't that it?
Fleming, yeah, Fleming, Harden.
545.060, Your Honor. Section A2, may not move from the lane unless that movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement was made unsafely.
So the whole issue, you know, they're going back and forth about the statue and everything.
Right.
But the problem is that he blew a .19.
Yes, but he's saying that
they didn't have a reason to stop.
They didn't have a reason to stop because the reason why he blew that was because they pulled him over.
They pulled him over,
and they weren't justified in pulling him over. In other words, his lawyer is he's arguing the case to try and get this thing dismissed because on a technicality, which again, this is what you get. This is why it's very important that you do not sit there and you don't waive things. You make sure you're there for your court appointed.
Because he's going through what the reason, different reasons why you can't pull over to the shoulder and do something or whatever. Because once again, you could be driving in the road and now you see somebody stopped, so now you got to go around them. How are you going to go around them? So I'm
going to shout out to the defense attorneys and public defenders because these public defenders are on point. He is doing his thing. He is not playing. He is making sure his client's getting his money's worth. He's doing his thing. See how this works out.
I also have the list of, where under Texas law where it's permissible to drive on the shoulder, to stop, stand, or park, to accelerate before entering the main lane of traffic.
Let's do this. I mean, this is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go? Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time.
Yes, sir.
Right? Give you time to take a look more so if you need to. You too as well, if you want to try to find a case law. Let me just go through because I have another lawyer that's waiting,
Absolutely.
Yeah, I'll help you out, but let me get through everything. Yeah, for sure.
Just gotta get with the sheriff's and prosecutor.
So they're going back and forth with these little nuances of why you can and cannot stop at the shoulder of the road.
So the judge adjourned it to see what happened and said, hey, got someone else waiting. Let's revisit this.
Because you know that
it looks like this is going to be drawn out. They're both going to
be right and wrong at the same time.
Basically.
But he has to decide because this is probable cause right now.
Correct. And on top of that also, he's seeing that it's not a one and done. This is going to be a long drawn out. This is going to be a kind of a fight. So,
and even though they actually did catch him, like I just said earlier, they did catch him.
He was wrong.
And he was under the influence.
We are definitely not saying he's not wrong.
The reasoning as to why they stopped him is what might get everything.
Yes. The defense is saying as if there was no part one, so there was no reason you wouldn't have found out about part two. There was no reason to pull him over, so you wouldn't have found out that he was intoxicated because you had no probable cause of pulling him over.
It called? Like fruit of the poisonous tree?
Fruit of the poisonous tree, yes. That's exactly what it is.
Hey. I wanted to reapproach regarding the PC on Mr. Allen's case. I know the state has emailed me some cases that they wanted to cite to.
Morgan.
Judge.
I don't know whether someone else wanted to speak to that.
Yeah. If we may, upon reviewing case law, so as we've discussed before, so he did veer into the shoulder and then go back onto the lane. And in Hardin, failing to maintain a single lane with the added vehicle component is the danger that they provided in the case law that makes failure to maintain a single lane, unlawful. Furthermore, in cases such as Lamming and Martinez, the court added additional factors to consider for the officer into determining whether or not failing to maintain a single lane is unlawful. And one of those is the time component. In Martinez, it was at midnight or at 1 o'clock in the morning. Here it was midnight as well.
So the lawyer's citing a case
Correct.
where someone was stopped and they're saying that it was at night. And this person, at the time that this occurrence happened, this was also at night.
Right.
So they're trying
Like I said,
get it, saying that it wasn't the same amount of traffic.
No, it's
It
not.
wasn't the same. You can hear the traffic going by now.
Yeah.
No, but one of the things is there's an element of unsafetiness, right?
And Your Honor, there are other vehicles around. As the officer articulated in the dims, there are other vehicles around when he veered and then jerked back into the lane, as the officer put in the dims.
But I get it.
And then,
But where are the other vehicles? Are they next to him? Are they in front? Are they in back? He doesn't articulate it. All he says is there are other vehicles.
and furthermore, Your Honor, what he did articulate into the shoulder, and upon looking at the statute for that, the Court of Appeals in Lothrop v. State articulated that there are 7 permissible reasons to go onto the shoulder, and there is reasonable suspicion to perform a traffic stop where there is not one of those permissible reasons. And here, the officer did not, with those other vehicles saying he passed the green light and then go halfway into the shoulder and then jerk back, it implies that there is not one of those 7 reasons to allow another car to pass, to stop or park, or to accelerate before entering the main lane of traffic, or decelerate before making a right turn. None of those are present. None of the 7 reasons articulated in the statute on the Transportation Code 545.058 are present. So that alone, him going into the shoulder without a permissible reason, is enough to perform the traffic stop. And that, taking that into account with Hardin, which he veered out of, he failed to maintain a single lane with other vehicles around, provided enough of a community danger to allow the officer to perform that initial stop.
You see, they're both, the DA saying that they have 7 reasons why they can't pull them over.
Right.
The lawyer saying he has 9 reasons why he could go over
Lawfully.
They never are, the police officer never articulated exactly where the vehicles were. They just
usually
said
don't.
But you know what? They made it so general. He made it such a broad statement that it's so subject to interpretation that it can go either way.
Well, this is how case law is generated. These things like this happen. Then they go to the court and they cite the arguments. The judge makes his ruling. Based on that, you have a decision. And that's where case law is generated because of things like this. This is going to become case law because of the fact that they're articulating this problem. The problem with the fact that he was pulled over, and they're saying, well, had he not been pulled over, there'd have been no reason for the cops to have pulled him over, and they wouldn't have found him if he would have been arrested for DUI.
And they're saying that it didn't matter. The fact that he overcorrected was reason enough.
And he's saying, no, it's not reason enough. So let's see how this plays itself out.
Man,
Where's the danger?
It would be the other vehicles present, Your Honor.
He doesn't articulate that, though.
He does articulate that there are other vehicles.
All he says is there are other vehicles.
And that is all the case law requires. He doesn't have to say there's a vehicle right in front and right next to him. The case law requires that there be other vehicles within the vicinity for it to be.
Right. In the case law,
You don't know if it's in the vicinity, though. All he says is there are other vehicles. That's so vague. You say other vehicles in the vicinity. He doesn't say that they're in the vicinity. He just says there are other vehicles. And that's so vague and conclusory.
And Your Honor, the case law does specify there only needs to be a minimal level of justification for the stop. In this case, that is enough for there's other vehicles around to provide that additional threshold for failing to make a single lane. In addition to no permissible reason to enter the shoulder, there's nothing there to indicate there is a permissible reason.
If we're taking outside of the failure to maintain a single lane, and we can go into the other part of the transportation code that this defendant violated, which is veering onto the shoulder, he did not do so for one of the 7 permissible reasons, and thus the officer has reasonable suspicion to stop.
You're veering. That is 545.060, right? Isn't that part of that's the weaving, right?
It's a different one.
Because you just said there's another violation of the transportation code.
Yeah, and it's under 545.058 is for entering the shoulder.
Right.
This is a great back and forth. Both lawyers are really
This is
showing
such a gray area.
their legal acumen, and they're definitely going into the statute. They're actually this is why these things happen. They have to have case law and this stuff.
Once
instead
again,
of precedent.
it's so gray because they're saying he didn't do any of the 7 reasons why he could have veered over.
Mm-hmm.
So, and the judge is saying that it wasn't clear enough. But I think that they wrote the statement so that it could be like that. So it can be just enough to cause, the officer to say, hey, let me find out what's going on here.
Address the court, please, Your Honor.
Hold on, let me pull that code up. So that's
54058.
The transportation code.
All right, let's see. That is driving on an improved shoulder. An operator may drive on an improved shoulder to the right of the main traveled portion of a roadway if that operation is necessary and may be done safely, but only if to stop, stand, or park, to accelerate before entering a main travel lane of traffic, to decelerate before making a right turn, to avoid a collision as permitted by an official traffic device. Okay.
Yes, Your Honor. So in terms of their arguments about the driving on the shoulder under Lothrop, their case that they're citing, the case itself says, and I quote, merely driving on an improved shoulder is not prima facie evidence of an offense.
So they went to the actual statute.
Yes.
They brought it up.
Yes, they did.
And they said that just driving on the shoulder, they can go on the shoulder. He can go on the shoulder and then correct and go back into the lane.
It's not prima facie evidence for him to be stopped alone. You need prima facie evidence, for those who don't know, is evidence when presented is enough to proceed from that point. You don't have to bring anything else up with it. And he's saying it is not prima facie evidence. That's PRIMAFACIE. Let's hear the definition.
It's based on the first impression. It's accepted as correct until proved otherwise, which means he went into the shoulder, corrected, and kept driving straight. He was fine. He didn't keep swerving. Like, he would have had to have followed him, at least maybe 2 blocks or 1 block to be able to determine that he was impaired.
Right.
Now, he was able to prove that he was impaired because after he stopped him, he took the evidence.
Right.
But he didn't have the reason to stop him.
Right.
So even though he was right that he was impaired,
correct,
he didn't have on first impression
enough evidence.
He didn't have enough to stop him.
Exactly.
Because that one little thing that he did wasn't enough.
Which brings us back to your statement about fruit of the poisonous tree, because that stop alone, even though he didn't unlawfully stop them, he technically unlawfully stopped them. It's a line that they're walking.
And the definition of fruit of the poisonous tree is a legal principle in the United States that prohibits evidence obtained through illegal means from being admitted in court. If initial evidence is obtained illegally, any subsequent evidence derived from that illegal source is also considered tainted and inadmissible. This doctrine is an extension of the exclusionary rule, which aims to deter police misconduct by preventing the use of illegally obtained evidence in court. So when he saw him go and correct himself on the shoulder of the road, he could say, I felt like, but it would have had to been a little bit more. If he had seen him maybe coming out of a bar and getting in a car and then doing that, then he could have said
observation,
that. But based on his observation, but just this one action that he
which
did,
is basically a gut instinct, his gut feeling.
But this one action that he did was not enough to warrant him doing this. But since they have such a high DUI statistic,
Correct.
he's probably going with the probability that he's going to be more right than wrong.
Right. So he erred on the side of caution, which is why we're here. So a police officer's job is not to argue cases in court. He just affects arrest. Let the lawyers fight it out, which is what they're doing now. He affected arrest. As a result of his arrest, now his arrest, because of it, might be citing case law, starting a new precedent in case law, because case law is precedent citing for what happened under certain circumstances causing the arrest, whether legally or not legal. So that's not what they're arguing. Now we're arguing case law and possibly setting a precedent here with this case in itself.
Their case that says the exact, that doesn't benefit them at all. In terms of Hardin, their own case, based on our review of the record and precedent, we conclude that the detaining officer did not have reasonable suspicion to stop Applee for violating Transportation Code Section 545.060. Again, that's their case. And in that one, that's where the vehicle's tires crossed over the fog line, just as in our case, into the shoulder. And in their own case, it says that was not reasonable suspicion. And so, I would like to, highlight these two cases because I think they're directly on point. I don't know why the state did. In terms of State v. Hernandez, which is 2016 out of the Fourth Court of Appeals, and I have the appellate case number, but I don't have the specific site.
My only concern is there an element of unsafetyness? That's all I want to know.
To just address one point briefly, in the case Lothrop, they do say that really on an approved shoulder is not prima facie case evidence of an offense. However, if it states explicitly that the offense of illegally driving on an approved shoulder can be proven in one of two ways, either driving on an approved shoulder was not necessary part of achieving one of the 7 approved purposes which are articulated in the statute, or that it could not have been done safely. And here, we're again going back to the 7 articulated purposes in the statute that are not present here. He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory, then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code. This law can't be like that.
It wasn't just announced, he went halfway in. So he veered halfway into the shoulder. It wasn't just like a little deviation. He said, the officer said halfway into the shoulder and then jerked back into the lane. So he went out and then came back into the lane.
So are we supposing that that's like half a second of driving on an improved shoulder? Is it 1 second? Is it a minute? Is it?
I'm sure it should matter. I mean,
because the legislature articulated 7 specific reasons why that would be permissible, and they wouldn't have.
If an old grandmother who is 70 years old is driving on a freeway and accidentally
but that would provide the minimal justification just to perform an investigative, a stop, just to investigate. It wouldn't be an arrest or anything like that. It would.
Well, that's not a really good example because she could be grandma with the guns.
It is. Even if she was grandma, if she was grandma with the guns, that'd be a great example. But yeah, he's saying
that it just not justified. Once again, there's no video evidence. So once again, it's just the police officers. He's testifying that this is what happened.
Right. That was his probable cause for pulling him over. So, the judge is saying, well, wait a minute. It could have been
anybody going over.
He's saying anybody. Suppose it was an older lady who's not impaired, but she's just old.
And she might have said, "Is this where I'm going?"
Split second, she lost herself for a split second and then caught herself. So now what? She gets arrested for DUI. Right. She gets arrested. She gets pulled over and gets a ticket because for that 1 split second that she forgot where she was at because her mind drifted for a second. She gets pulled over. That's the argument that they're saying. And
also, you have sometimes where you'll have someone that they're looking for something,
right?
And you're like, wait a minute, is this it? Because sometimes you're like, is this where I make the turn? And you're like, oh no, this is not where I make the turn.
Right, exactly. Because again, you don't realize sometimes when you're driving, the way you're looking is where you start going. When you realize it's subconscious, your hand will turn that wheel in that direction you're looking at if you're not careful.
Which is why they say, keep your eyes on the road.
Exactly.
Keep your eyes on the road. And this is why the 1, 2, 3, the big picture, always doing all that. Because, you're supposed to be trying to see. So if he looked to the right, that would have made him make the call. And once again,
Yes, exactly.
let's not forget, he was technically impaired. So his thinking wasn't, he might not have done that normally, but he was impaired.
Yes. So while he's under the influence, you don't know what.
So then now if the police would have stopped him and he wouldn't have had anything on him, then they would have had to just deal with it.
Exactly.
They would have just asked him. He said, "Oh, I looked over there and I would just dripped it over there."
Just the traffic stop would be allowed at that point.
I don't know. I don't think that the officer wrote enough in the report. I don't think that the unsafetiness as far as, saying that there are other cars around, I just don't think that there's enough.
Yes,
Right.
Judge.
I'll find no probable cause.
Thank you.
Okay.
You see how it just turned 180?
Yes.
The judge was like, "Oh, probable cause. Yes, we have probable cause,"
Exactly.
and then now he was like,
Yep.
"No, we don't have
because his
probable."
lawyer articulated his affirmative defense on
And then
behalf of his
the
client.
officer was not clear as to why, because once again, it was such a gray area that you had
Yes.
to pick what was going to be, because he didn't define it clear enough to say, once again,
The report was
in
murky.
pursuit, and
The
this.
circumstances were murky. The statutes murky. Everything was murky. It was a whole bunch of gray areas, and because of that, because his lawyer was a great litigator.
Use that same gray area to say, well, according to this, this could be this too.
Right.
He corrected. Once again, he didn't follow him and see this. He
Right.
he pulled up behind him.
And
He did the green light.
Mhm.
What he was probably going to do is he probably was going to get in the right lane and get away from him.
No, he was going to pull over.
He probably was going to pull over.
I think he was going to pull over. See, traffic over here. He was going to pull over, but because he realized if I pull over,
then I'm going to be more likely to get stopped.
So
And
he
he got
said
stopped anyway.
So it didn't matter. Yeah.
Well, the lesson, boys and girls, is don't drink
And drive.
and drive.
That's
Don't
right.
drive under the influence.
Right.
Because it doesn't work. I don't care how great the statute is.
Right. And in Texas, make sure you put a signal on before you change any lanes.
Yes.
Not just only Texas, everywhere, but
Everywhere.
especially in Texas.
And in that county where
In
they
that
got
county,
that high
yeah.
impairment. Woo.
Yes, sir.
All right.
And that was a public defender. That was a public defender's office. That was not a paid litigator. That was a public defender, from what I can see.
But
Now, if he paid, it's even better. But these public defenders in Texas, they're no joke.
remember,
And in Michigan.
this is not a one and done.
No, it's not.
Remember, this is why they talk about you defending yourself. These
Right.
lawyers have experience of having done it. Another colleague may have done it. This is what defense they use. Hey, if you ever have a problem with this, this is the defense we use, and this is the defense that usually, this is the defense that usually
Right.
works, and we do this. If this is the circumstances, you can argue this, because once again, that's how all these laws and precedents come into place.
Right.
It was argued in one, and that's why they go back and cite that same argument
Right.
and say, this is what won last time.
Right. And
Can
now,
we win with this one again?
and I'll go further. And now these lawyers today are earning their money because of the remember, there's more people now on the planet than there were back in the days. There's more people. There's more incidents going on everywhere than there were back in the days.
The judge doesn't take 6 weeks to come out on his horse.
No, he's not coming. Nope. They're not calling for the territory. Nope. And you notice he didn't use the Chewbacca defense or the Kobayashi Maru.
Yes.
Neither one of them. So the bottom line is they're earning their pay. So even though they used to get a bad rap in his movies, you can see I'm not going to cite the movies, even though they're great movies showing how the public defenders drop the ball. But no, this guy here, he sat there, he swayed the judge. He moved the position. The judge came up blazing. I see probable cause, and he swayed him back in the different direction, like you said. So again, public defenders are getting a bad rap. But these public defenders out here in Texas and the ones in Michigan from seeing so far, they're all pretty good. They're tight with their litigation.
Thanks for watching.
And also give us a thumbs up, like, comment, share. Subscribe to the channel, and you'll be notified of every video as they come up. And get that algorithm going and help us build this channel.
And make sure that you don't wind up in a what had happened situation. Boom, boom, boom.